As you've seen from the program, after the speeches there will be the transformation dance, and we're hoping we can have the smoking ceremony at that time. So thank you, Mr. Olsen. I'll give you that.
Thank you. Yeah, my name's Terry Olsen. I'm an Anawan man, Gamilaroi man, so it makes me a freshwater man. That's why I'm doing an acknowledgement. I'm not from this country. Welcome to country is done by people that are actually from the area. If you're visiting or a guest to the area, you can do acknowledgements, and that's what have been blessed with being able to do in the past here in Sydney. So, as an Anawan Gamilaroi man from northern New South Wales, around Armidale and Tenga and Inverell, I want to acknowledge that I am down here on Gadigal country, here in the Sydney Basin. The Sydney area and the peoples here, there were 29 different clans in the Sydney area, in the Sydney Basin, and that's from the Nepean River to the west, the Hawkesbury River to the north, Georges River to the south, and of course our great coastline. And as I said, 29 different clans here, and they were fortunate enough to be freshwater, saltwater, and in some cases both fresh and saltwater. So I acknowledge that they had quite a bit of diversity in their habitats and their lifestyles and their diets, and also their cultures and their dances. So I acknowledge that today, and I thank the elders past and present, and also here today, our Aboriginal people, elders past and present, and also any emerging elders as well. Thank you for having us today. We'll be doing a performance for you a little bit later on, I believe, after you have some of your formalities. And myself and my two friends from Tribal Warrior will be doing some dances for you later on. And hopefully the lady with the smoking might be here by then too. But other than that, thank you very much for having me. And we'll see you a little bit later. Thank you.
Thank you, Terry. I think we'll just make our way into the courtroom now for the ceremonial sitting. Thank you.
Honourable Court now draw nigh. Give your attendance and you will be heard. God save the Queen.
Chief Justice of New South Wales, the Honourable Andrew Bell, the Attorney-General of New South Wales, the Honourable Mark Speakman SC, judicial colleagues, distinguished guests, ladies and gentlemen. I begin by acknowledging the traditional custodians of the land on which the John Maddison Tower sits, the Gadigal people of the Eora Nation, and pay my respects to their elders, past, present and emerging. In particular, I acknowledge and pay my respects to the elders and respected persons and senior Aboriginal client and community support officers who are present and will assist the Walama list judge in the sentencing and Walama case plan conversations. Mr. Terry Olsen, thank you for your welcome to country. It is indeed fitting that this formal part of the ceremonial sittings has been preceded by your welcome to the country and is to be followed by the butterfly transformation dance and the smoking ceremony to be performed by Sarah Johnson, Mr. Olsen and Dave Barnett, who I also thank. In 2001, a circle sentencing trial commenced in the local court at Nowra. Circle sentencing, based on traditional Aboriginal forms of dispute resolution and customary law, aimed at addressing the overrepresentation of Aboriginal people in custody and achieving greater community involvement in the sentencing process. Following the successful outcomes achieved in the Nowra trial, I had the privilege, as Chief Magistrate of New South Wales, of permanently establishing the Circle Court at Nowra and commencing Circle Courts at other regional locations, including Brewarrina, Dubbo and Walgett. In a study by the New South Wales Bureau of Crime Statistics and Research, published in 2020, almost 19 years after the Nowra trial, the Bureau found that Aboriginal people who participated in circle sentencing have lower rates of imprisonment and recidivism than Aboriginal people who are sentenced in the traditional way. At my swearing-in ceremony as a Justice of the Supreme Court in August 2006, I said, and I quote, "Innovative work has been undertaken in the local court in the field of sentencing. Programs are being developed with the aim of diverting offenders from the crime cycle. These programs include young adult conferencing, which brings an offender and victim together, and circle sentencing based on traditional Indigenous forms of dispute resolution and customary law with community involvement in the sentencing process. Consideration might be given, in my view, to extending these initiatives in the appropriate cases beyond the jurisdictional limits of the local court. For example, at the present time, an Indigenous offender who commits the crime of break and enter and steals $14,000 from a dwelling house at Nowra may be sentenced with the assistance of a circle court, whereas should the same offender steal $16,000, the offender is sentenced in the district court. Almost 16 years have passed since I made those remarks. I am pleased that the district court will now have a sentencing list, the principal objectives of which include reducing the overrepresentation of Aboriginal and Torres Strait Islander persons in custody in New South Wales, increasing Aboriginal and Torres Strait Islander community participation and confidence in the criminal justice system, and reducing the risk factors related to reoffending. Mr. Attorney, may I express my thanks to you for your support for the Walama list. I'm confident that as the Nowra Circle sentencing trial demonstrated, the Walama list will achieve lower rates of imprisonment and recidivism and will progress to a Walama court with an appropriate legislative foundation. I also express my gratitude to Judge Yahir SC, who has worked tirelessly towards establishing a Walama court. Judge here has demonstrated patience, negotiating skills and sheer determination. Without her efforts, the Walama list would not have been achieved. The Walama list has been a collaborative enterprise and many here have made significant contributions. I thank all of you. Judge here.
Thank you, Chief Judge. I commence by acknowledging the traditional owners of the land upon which we gather today, the Gadigal of the Eora Nation, and pay my respects to their elders past and present. I also acknowledge the strength and resilience of First Nations peoples and their continuing connection to lands, waters and culture. I acknowledge all First Nations peoples with us today, and in particular our Walama list elders and respected persons. Uncle Charles Mundine, Auntie Susan Wordoff, Auntie Patricia Fields, Auntie Elizabeth Burke, Auntie Thelma Cordy, Robert Leslie, Auntie Barbara O'Neill, Lorraine Leslie and Uncle Shane Phillips. Mr Attorney, Chief Justice, the Chief Judge of Common Law, Justice Hamill, Justice Adams, Justice Pepper, the President of the Law Society and President of the Bar Association, distinguished guests, you honour us by your presence here today. This is a momentous occasion in the history of the New South Wales District Court. It is, as you've heard, the first time that this court will have an Indigenous sentencing list, which will bring a holistic approach to sentencing so that we can meaningfully address an offender's needs and underlying issues. This audience is acutely aware of the disproportionate rate of Aboriginal and Torres Strait Islander people in custody. It has been said that the overrepresentation of Indigenous people in custody is a crisis and a source of great shame. Much has been said over the years about reducing the rate of Indigenous people in custody and providing alternatives to address in a more meaningful way offending conduct. The Walama list is the way in which this court will address these issues. Walama is the Darug word that means to return or coming back. And in the context of the list, it is a return to identity, a return to culture, and a return to a healthy, crime-free life. Our objectives include reducing the rate of Indigenous people in custody, reducing the rate of recidivism and increasing the rate of compliance with court orders to make communities safer, to engage in a more meaningful way with offenders and in some instances victims, to increase the confidence amongst First Nations peoples in the criminal justice system and to engage more positively with those communities. The process will enable Aboriginal and Torres Strait Islander community participation. We will utilise appropriate programs and supports to address needs and risk factors that may impact upon the offender's continued involvement in the criminal justice system. You might be thinking that this is an ambitious task. It is. I don't think anyone is pretending that it will be easy, but it is a start and it is a hopeful start. As judicial officers, we are too often faced with the evidence of the negative aspects of the life of an Indigenous person, their trauma, disadvantage and deprivation. That material is both important and necessary. What we lose sight of, however, is the strength and resilience in community. We lose sight of the fact that culture is powerfully healing. We forget that the experience, wisdom and knowledge of elders and other community members can inform our decision-making and assist us in formulating the appropriate penalty. Walama will focus on the strengths. It will do so by listening to the voices of First Nations peoples through our elders and respected community members, the service providers, including, importantly, Aboriginal organisations, and by embracing culturally appropriate rehabilitation programs. We didn't get to this point without the support and hard work of many. I know that brevity is the friend of a good speech, but I am going to take a few minutes to acknowledge and thank a number of people. At the top of that list is our Chief Judge. In March 2015, about 10 months after I was appointed, I emailed him to ask whether he would be open to an Indigenous sentencing court in the District Court. I must admit that I was somewhat anxious about how he would respond, given that I didn't know him very well at that time. Within a few minutes of sending the email, he responded with something along the following lines, and I apologise in advance if this is oversharing. Great idea. Get it done. One piece of advice. Don't get bogged down in committees. Chief Judge, your support was not only immediate, it has been unwavering over the last 7 years. Without you, there would be no Walama list. This is a significant legacy. To the judges on this court, your support and enthusiasm for the Walama list has been overwhelming. Many of you have already expressed your desire to sit as a Walama list judge. I think we can all be proud of this initiative. Mr. Attorney, you have publicly acknowledged that we can and must do better. You have identified the importance of continuing to work hand in hand with Aboriginal communities to reduce the overrepresentation of Aboriginal people in the prison population. One of the ways in which you have demonstrated your genuine commitment to these issues is by your support for the Walama list. Thank you for that support. Mr. McHugh and Ms Vanderpat, each of you, your predecessors over the last 7 years, and your members have supported the Walama proposal. It is very heartening to have the support of the profession. To the Walama Working Group, which has included representatives from various organisations, including the Public Defenders, the Aboriginal Legal Service, the Legal Aid Commission, the DPP, Community Corrections and Corrective Services, many of you are here today. I want to particularly thank you for your commitment over the last 7 years. You have given up your time to attend countless meetings, prepare the original proposal and business case, deal with challenging issues that have arisen, and importantly, never wavered. Amongst that group, I want to take the time to thank my associates over the past 7 years. They have essentially performed 2 roles, supporting me in the work of the court and supporting me in the work of Walama. I want to particularly thank my current associate, Ms Al-Majid, who has even compiled and prepared a spreadsheet to capture the data necessary for the evaluation. I'm happy to report that the Walama Working Group will continue to meet, to monitor the progress of the list and address any issues that might arise. Over the past 6 months or so, we have worked closely with the Aboriginal Service Unit, led by Edwina Crawford. This is a team of formidable, committed and skilled women. The members of that team are Catherine Lomas, Diana Newman, Penelope Josie, Vanessa Sakala and Annette Hennessy. In a short space of time, you have attended to the recruitment of elders and assisted in preparing and presenting the various inductions, documents and processes necessary for the operation of the list. Without you, we would not have been ready to commence. I have left the most important participants in the Walama list until last, to our elders. As I said earlier, you bring your wisdom, your experience and your knowledge to the process to assist us in fulfilling the objectives of the list. You also fulfil the very important objective of educating the profession and the judiciary by contributing a very different narrative, a First Nations narrative. To the service providers and representatives from grassroots community organisations, many of you are here today. You have repeatedly expressed your commitment and willingness to work with the Walama list by providing dedicated caseworkers, culturally appropriate programs, and general support and guidance to the offenders. You have considerable experience and an understanding of the issues and challenges involved. It is not going to be easy, but real change never is. I am confident that we will make a difference. Thank you, Chief Judge.
Thank you, Judge. Mr. Attorney.
This time. May it please the Court, I too acknowledge that we gather on the traditional land of the Gadigal of the Eora Nation. I pay my respects to their elders, past, present and emerging, and I pay my respects to all Aboriginal people who join us today. Proportionally, we are the most incarcerated people on the planet. We are not an innately criminal people. Those words, of course, come from the Uluru Statement from the Heart. And all of us know some of the shocking statistics. That while 3%, while Aboriginal people represent 3% of the state's population, they represent 27% of the adult prison population. And in the December quarter across Australia, 1 in 23 adult Aboriginal men were in prison. The causes of Aboriginal overrepresentation in our criminal justice system are numerous and long-standing. The largest causes sit outside the criminal justice system. Matters like poor educational outcomes, high unemployment, poor economic opportunities, poor housing, drug and alcohol addiction, and social dysfunction caused by intergenerational trauma and dispossession. But that said, we can't ignore that the criminal justice system makes matters worse. And that's not just anecdotal, there's some robust evidence that it does. In bail outcomes, Boxar tells us in its 2021 report that adult Aboriginal defendants are 20% more likely to be refused bail by police, even after accounting for other relevant case characteristics. And we've seen this in sentencing as well. For example, in the Sentencing Council's report on sentencing for assault on emergency services workers, it's noted that in 2019, 24% of Aboriginal offenders received a sentence of imprisonment for assaulting a police officer. That compares with 12% of non-Aboriginal offenders. 51% of Aboriginal offenders received a sentence of imprisonment for assaulting a police officer occasioning actual bodily harm, compared with 30% of non-Aboriginal offenders. So we've seen low participation rates of Aboriginal people in diversion programs, and that's due to a variety of factors. Strict eligibility requirements that have disproportionately excluded Aboriginal people, inconsistent use of discretion by police and judicial officers to divert a defendant, a lack of services and facilities to support the provision of diversionary opportunities in regional and remote areas, a lack of culturally appropriate or targeted diversionary opportunities, and a mistrust of the police and legal system. They're matters that were identified in that Sentencing Council report. So today, the Walama list is a pilot. At the moment, it's not a legislated permanent court, but I hope it becomes one. Why is it a pilot? Because at the moment we can't be certain that it will work. But I think we can be certain that it's the right thing to do. Why is that? First, business as usual will not reduce Aboriginal overrepresentation in our criminal justice system. One of the closing of the gap targets is to reduce the rate of Aboriginal and Torres Strait Islander adults held in incarceration by at least 15% by 2031. But not only will business as usual fail to reduce that rate, all the indications are that the rate of incarceration is likely to continue to increase without changes that attack the underlying causes and further interventions. And second, the Walama list borrows concepts from other programs that have worked, so there's great cause for optimism. Your Honour, the Chief Judge mentioned circle sentencing, and in 2020 Boxar released a report that showed when compared with Aboriginal offenders sentenced in the traditional ways, offenders in circle sentencing were 9.3 percentage points less likely to receive a prison sentence and took 55 days longer to reoffend if they did reoffend. And we know that the Walama list borrows concepts from circle sentencing. It also borrows therapeutic and interventionist concepts from the drug court, and we know that that works as well. In 2008, Boxar found that participants in the drug court were 17% less likely to be reconvicted for any offence, 30% less likely to be reconvicted for a violent offence, and 38% less likely to be reconvicted for a drug offence at any point during the follow-up period. That was a study which looked at short-term reoffending. In 2020, Boxar looked at long-term reoffending and found that participants would take 22% longer to commit a person offence, an offence against the person, and recorded a 17% lower reconviction rate compared with the control group. Of course, there are other measures that have been introduced in recent years to increase diversion with an aim of reducing reoffending and reducing overrepresentation of Aboriginal citizens in the criminal justice system. Reforms to community sentencing in September 18 removed community service work as a mandatory requirement, which had the potential to block the access of Aboriginal people to that form of sentencing. In 2020, Boxar found that among Aboriginal offenders in the local court, the percentage of offenders who'd received a supervised community order had significantly increased from 25% to 37%, while the percentage who'd received a short-term prison sentence had declined from about 13% to about 10%. Driver disqualification. Prior to driver disqualification reforms in 2017, almost a third of those who were imprisoned for unauthorised driving identified as Aboriginal. Now, under the reforms, there has been a 36% reduction in the average aggregate prison sentence for unauthorised driving offences for Aboriginal offenders, and a 60% reduction in the number of Aboriginal people in custody where driving while disqualified or suspended or driving without a licence is their most serious offence. And the government will have more to say about further diversionary reforms, I hope, in the very near future. The answer to high rates of offending and incarceration in Indigenous communities is not to turn a blind eye to serious crime and to retreat. That would do a disservice to community safety and community harmony, particularly to the safety and well-being of Aboriginal people who are often the victims of crime themselves. The Walama approach doesn't do that. It's not turning a blind eye to offending and retreating. It seeks to deal with the causes of offending that are particular to an individual and to treat those causes. It's not lenient. It doesn't involve offenders failing to take responsibility. And while I've said a lot about reducing reoffending, and that's a key driver of this pilot, it's not the only consideration. The pilot is also about driving community cohesion and community trust, the trust of Aboriginal communities in the criminal justice system, as well as giving Aboriginal communities a voice in the outcomes and the processes that affect their communities. I thank and congratulate the Walama Working Group, particularly Your Honour Judge Yahia, for your tenacity and advocacy over many years. I thank the elders that will participate in this pilot. The court will be working hand in hand with Aboriginal elders and respected community members, and I pay my respects to all of them that are here this morning. The role you will play in giving honest and fearless advice to the court, drawing on cultural knowledge, wisdom and experience is vital. You'll be playing such an important role in assisting the court during the sentencing and case plan conversations to identify culturally significant issues and culturally appropriate programs or supports that might be included in the case plan. And that participation sends a clear message that the offences committed are not condoned by either Aboriginal and Torres Strait Islander or non-Aboriginal communities. I look forward to hearing about the successes of the Walama list. Just as the Darug word Walama asks you to return, to come back, I ask, Yera la Yera, Lali bi Lia. Let's walk together. May it please the court.
Thank you, Mr. Attorney. Mr. Brendan Thomas, Deputy Secretary, Aboriginal Outcomes, Department of Justice. Mr. Thomas.
Yinjamara, Nyaymaldain, Jirma Delinia, Gadigalja Dagunda, Yinjamalija Gadigal Mujigang. With thanks to the court, I'd like to acknowledge that we meet on the lands of the Gadigal people and pay my respects to their elders, their families, and to their beautiful country that we meet on today. Walama is a word from the Darug language which means to come back or to return. In the context of the Walama list, it's coming back to identity, to community, to culture and a healthy crime-free life. The Walama list is the first Indigenous sentencing list in one of Australia's oldest courts, the District Court of New South Wales. And it's another example of the New South Wales judiciary sharing authority with Aboriginal people. For the past 2 centuries, the law in New South Wales has largely operated to oppress Aboriginal people. Over much of that time, Aboriginal people haven't seen courts as instruments to protect our rights, but as instruments to take them from us, which is why it's so important to recognise the continued leadership of the New South Wales judiciary in taking bold steps to share authority with Aboriginal people and make significant changes to the court to do it. We've seen it in circle courts, in the Koori Court, and now in this Walama list. And I'd particularly like to thank the leadership of Chief Judge Derek Price and Judge Dina Yehia for their continued pursuit of this kind of justice in New South Wales. We know that every time a court involves Aboriginal people, its decisions are better. The information gathered is so much richer and the conversations more meaningful. We know those decisions are more likely to be seen as legitimate in our community and to be more effectful. The Walama list aims to reduce reoffending and keep communities safe. And it will do this by involving elders and respected community members. They'll give frank and fearless advice during sentencing and case plan conversations to the Walama list judge. They'll support informed judicial decision making that holds offenders accountable and allows discussion to focus on important cultural insights that can empower offenders to change their behaviours and stay engaged in their rehabilitation. Elders and respected persons will also advise the Walama list judge on cultural issues relating to the offender and to their offending behaviour. The Walama list judge will have the opportunity to better understand the unique kinship, connections and cultural ties of each offender and invite in community perspectives relevant to sentencing. The Walama list elders and respected persons symbolise the importance of Aboriginal and Torres Strait Islander cultural authority in decision making and where Aboriginal authority and judicial authority meet. In March 2022, the first group of 7 elders and respected persons were inducted to the Walama list, and tomorrow some of them will participate in their first sentencing conversations. To those elders I say, Yinjimara Mandango. Thank you for your courage and for your commitment to our community. Their involvement will undoubtedly support greater Aboriginal and Torres Strait Islander community confidence in the criminal justice system through their participation in this Walama list. I'd like again to acknowledge Judge Dina Yehia, who has been appointed as the Walama list judge, along with Judge Hunt and Judge Weinstein, who will support Her Honour with the Walama list. Judge Yehia has been instrumental in leading and developing the Walama list. I'd also like to acknowledge Edwina Crawford, Diana Newman, Vanessa Sakol, Narelle Hennessy, Catherine Lomas, and all of the staff of the Aboriginal Services Unit who've worked so hard in setting up this list. I look forward to supporting the work of the Walama list and its contribution to helping empower Aboriginal and Torres Strait Islander offenders with the support and the tools they need to live a life free of crime. Thank you.
Thank you, Mr. Thomas. Is it Weena Crawford, Director, Aboriginal Services Unit, Department of Justice?
Thank you. If it pleases the court, I'd like to begin by acknowledging that we're on the land of the Gadigal people of the Eora Nation and acknowledge and pay our respects to those elders past, present and emerging and their continual connection to the waters and lands and culture in this area. To the Chief Judge, the Attorney General, the Honourable Mark Speakman and distinguished guests. The opportunity for the Aboriginal Services Unit to partner with members of the judiciary is something that is quite challenging and exciting at the same time. Our mission is to build better pathways to justice for Aboriginal people, and we do that in a number of ways. But one of the special ways in which we do that is working with courts to transform the traditional court processes into something that helps transform the current way that we do business. The perspectives and insights from members of the judiciary are unique. You are at the back end, but you do provide a perspective that's important for us to understand, and more importantly, understand what we could do about that. The Walama list is a way in which we're trying to change things in the district court. Taking inspiration from other jurisdictions, Judge here, with the approval of Chief Judge Price, set upon a very long journey to this point here. I remember in some of my early days in this role, in 2014, coming across the original proposal for the Walama list, for the Walama court at the time, and thinking to myself, wouldn't it be great for New South Wales to have the trifecta, something in the Children's Court, something in local court and something in district court. I know how hard you've worked to get to this point. It's not quite the court, but sometimes the second best option might be the more effective one, you never know. Her perseverance, determination and resilience through this process is something that I've come to admire. And to take an idea and to turn it into something of a reality is something that I really commend. Judge here has represented both Aboriginal people and presided over matters in some of the most vulnerable parts of New South Wales. She's really well placed to understand what's the challenges in front of us, and in particular Aboriginal offenders, and then the judiciary and the role that it can play. During this time, she's really earned the respect of the Aboriginal community in New South Wales, and whilst we were advertising to recruit our elders and respected persons, a number of people thought that this Walama list could not be in better hands. So it's a real testament, Judge here, to your commitment to doing better and taking your role and really challenging the district court to do things differently, and it's been an absolute privilege to help you bring Walama List to life. A really fundamental part of the list is that the community holds the keys to changing offenders' attitudes, and at the heart of Walama List are our 7 elders, our magnificent 7. They bring to the Walama List several generations of lived experiences, expertise in the criminal and juvenile justice system, and they all have a deep desire and passion to support our participants in Walama List and also create safe and strong Aboriginal and Torres Strait Islander communities. Now, we've known from circle sentencing that involving elders and respected persons in sentencing conversations and discretionary decision-making in courts not only gives the participants and the offenders a place to feel safe, but it also gives that legitimacy to the work that we do. And we know the evidence from Circle is that it improves the chances of reducing reoffending as well as imprisonment for Aboriginal and Torres Strait Islander participants. Now, Walama List has begun from humble beginnings. It's not quite the court that we wanted, but sometimes I think that's the best place to start, because you have to learn how to make better use of what you've got. You start to question the systems and processes that are in place when you don't have the resources that you need, and you can sometimes generate even more changes with less. So we're really excited. I think it's a big part of the work that we do in the Aboriginal Services Unit. We're constantly looking for ways in which we can squeeze out the most of the things that we have in front of us when we don't have what we need to do what we really like to do. And while today we celebrate the Walama List commencing, it is, as Judge mentioned, a very hard task ahead. Vanessa Sakel, who's the Senior Aboriginal Client and Community Support Officer, who's been conducting all of the intakes for the Walama participants, has heard firsthand of some of the challenges that are in front of our participants. District Court is a serious court. It's significant matters and significant offending, and Vanessa has learnt of the unresolved trauma and grief and loss from some of our participants and some of the circumstances which have paved the way for their offending behaviour. But we know that this process, if we give it time to breathe and learn and grow and evolve, that we can really help change the pathway and the trajectories for some of our offenders. We can hold them to account, but also empower them with the tools and support that they need to live a life free of crime and be really productive members of their Aboriginal and Torres Strait Islander communities. So with that, we're very excited to be a part of this process, and even more excited, one of the parts of the Aboriginal Services Unit that we take very seriously is building a robust evidence base about what works in reducing Aboriginal offending, and we are very excited to be partnering with the Bureau of Crime Statistics and Research, who will be doing an evaluation of the Walama List. And yes, it will take time, but that at the end of that process we will have gold standard, robust evidence about the work that we do and the value that it adds. And I'm very confident as well that we will see the change. And I just hope that we can stay the course, that we can ride out the bumps, because as we've known from circle sentencing and youth Koori Court, some things don't always go to plan. But we are doing things in a way that are different and innovative, and that comes with risk. And we hope that people can take on that risk with us, and that we have that opportunity to get to the end of this trial and see the importance and the value that it adds. On behalf of my team, their names have been mentioned already, but I'll mention them again. Catherine Lomas, Vanessa Sakal, Diana Newman, Penelope Josie and Keegan Williams, our intern, have all been really critical parts of getting us to this point, and it's been an incredible journey for us to be working with the District Court to help bring Walama List to life, and we look forward to seeing the participants, most importantly, generate really good outcomes so they can stay out of the justice system. Thank you very much. Oops.
Thank you, Ms Crawford. If you join us now for the butterfly transformation dance in the foyer, the court will now adjourn.
Full stop.
Rowena's here. She's doing our smoking ceremony. It's a blessing and healing ceremony that we have in our culture. We use it for coming to new places, acknowledging past, also for change. Like you have some going on in your organisation. But also a smoking ceremony is not just on a professional level and your work, but on a personal level, to say you might have some own worries yourself with your own health, your own family. Maybe you've got a Year 12 student starting your HSC this year. You've got some worries going on. You might have family that is still unable to get to, and we've all had COVID issues for the last couple of years. So this is a blessing and healing for everyone to take on board, not just here as your organisation, but on yourselves as well. And the energy that you get from this today, you can take that home and share that with all your friends and family. Give them a hug, give them a little bit of blessing and a bit of warmth as well from what you've taken from today. The girls and I are going to do some dances for you. The first one will be called Walama. It's a welcome dance. It's from far north Queensland, in Lisa's country, and so we've got Lisa and Sarah. So our first dance will be welcome, Walama. The next dance we have for you is called Taraganu. Again, from far north Queensland, where Lisa's from. And I also want to acknowledge Lisa because these are songs from her family and her culture and her country. And so we're blessed to have her down here to share them directly with us. This next one we have for you is called Numpy. It's about the emu. And basically, one of our main sources of food, obviously, and that's why it's on our coat of arms, because they represent what they hope for the future of Australia. But for our people, those two animals sustained us and kept us going in many different ways. So, to Robin. Fun. So this next dance, I'm going to be singing this one. This one is, I'm just going to teach you how to count to 5. All right? So you ready? Repeat after me. 1. No, only kidding. Ready? Yabble. Bulu. Yabble bulu. Bulu bulu. Dange. All right. Comes from my cousin Gumroy, who shared with him from one of his cousins in southern Queensland, around Waka Waka. So, yabble. Bulu. Yabble bulu. Bulu bulu. Dange. Now try and put them together. Yabo bolo, bolo, dange. Have a go. Yabo bolo, dange. All right, so this dance, a bit of fun dance, a bit of show-off dance. You'll see the girls doing different styles and having a bit of fun. So this one here, Yabo bolo, counting to 5. Yabo bolo, dange. 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 Sounds like it wasn't just a dance, it's actually fun out there, right? All right, so this next one we have for you.
We're not supposed
This is going to sing.
once they've got.
It's about this. It's again about change and morphing. So in this dance, you'll see again, Sarah and I having a bit of fun, a bit of style, and you see us changing as we
I'm not saying that
go
can't
through
happen, but that
different
is
creatures,
very
snakes,
unusual.
birds.
The jurors are going to go home,
Bird.
so is her honour going to give leave for
Aspects of
us to move
dance
forward
and
to
stuff like that.
King Street?
Bit of a style dance and again a show off dance.
Appropriate?
Um,
I mean,
yeah, and
that's,
got to have to go get her voice back. So
yeah, I mean,
this one, I hope you enjoyed. This goes a little bit long with what you're trying to do today.
if they are
It's
provided,
a bit of our
it's
acknowledgement.
fine, we can give them that,
Thanks to you for what you're.
but what happens to the folders?
Good luck with all of that as well. Yelly, yelly.
Would you have thought of that? No, she said it would be disrespectful, which it would be.
Absolutely.
Yeah. So I was sort of
So
saying,
this comes to our farewell dance. Thankfully for Lisa.
well, otherwise use
Use
the judges.
use the
I want to say on
judges
behalf of the Tribe Warrior,
is an option.
thank you for having us.
Other judges are all watching.
The Tribe Warrior dances.
They're there, but I mean, you've got to do your work.
I
And
noticed when,
someone said to me, Lisa said,
Acknowledgments being done to the
you
elders.
need to do that.
Shane Phillips was amongst that. He's out
Use
of
the
the
judges.
he's
So that's what you should do.
Now too, or-
I better check that I'm allowed to do that. I'm allowed to go, but I would just use the judges.
he's from up north around Lismore there. Been up there with the flood relief for quite some time. So he'll be back when he can. This goes out a little bit to him too. Gillang Manang, our farewell dance. In all of our languages across this country, we never had a word for goodbye. We'll see you next time, next hunting trip, next billabong, next life.
Next minute.
Yep,
Terry, thank you so much. What a wonderful way to end our ceremonial sitting. Thank you so much. Thank you. Those of you who can now stay, and thank you very much for all your attendance this morning. We're having morning tea in the judges' dining room, which is just through that door. I hope you can join us. Thank you very much.